the procedure taken by the House in passing this law violated the Constitution. Let's start with quorum. The Speaker did not take the necessary steps to confirm before the vote on the bill that there was quorum in the House. And secondly, she did not make a record of the voting on the bill. So first, she's supposed to do a head count at the time the bill is being voted on.
A head count.
A head count, and say there are at least 30% of the members entitled to vote in the House. Then secondly, when the vote is done, she's supposed to make a record of how many people voted for, against. And abstained. And you see, the Constitutional Court determined that this year, in a case called Alternative Digital, when they nullified Nseriko's bill, you cannot pass a law by saying the A's have it.
And the nays have it.
No, when the A's have it, then the nays don't have it. Yes.
Have it.
Yeah, you can't do that anymore.
I'm Justin Safari, and this is the Policy Digest. So the Protection of Sovereignty Act is now law. Supporters say that it is supposed to protect Uganda from foreign influence. However, critics say that it could likely shrink civic space in Uganda. The law has been assented to, and one may ask, is this a new chapter in Uganda's governance? The political battle may be over, but the constitutional, legal, and practical questions are just beginning. Now, to go into this, I am joined by Phillip Karugaba, a lawyer who has been involved with the bill. It's very a pleasure to meet you.
Thank you very much, Justin. I'm profoundly honored and exceedingly humbled to be here.
Yes. So, as we start, before we get into it, how would a normal Ugandan understand sovereignty? If you had to explain to Omuntu and say, even normal Ugandans, really, because it's a technical kind of issue, like a legal technical term.
Yes, sovereignty. Yes, somebody had to teach me how to pronounce the word. Sovereignty, yes. So it's a right of a people to make their own choices about their country. Okay? For Omuntu Wawansi, to put it as simply as possible, let's call it bwananyini. Ownership, bwananyini, and what goes with it. Okay? What goes with it? As you understand, bwananyini, whether it's about chicken or your house, if you have ownership, over the rights that you would have in that respect would be sovereignty in a nutshell. Yes.
All right. Are there provisions for sovereignty before we get into that?
Yes. And it is the most fundamental thing. The Constitution. Okay, I like it in Luganda where they say Semateka, because Semateka connotes the biggest of the laws. Okay, the biggest of the laws, the Constitution. Article 1 is titled Sovereignty of the People. Okay,
of the people.
Of the people. And that's a good point you're making there, Justin. It's not of the state. It's not of the government. It's not of the UPDF. It is sovereignty of the people. Okay, and Article 1, Sub-Article 1 says all power belongs to the people who shall exercise their sovereignty in accordance with the Constitution. Okay, that is Article 1, Sub-Article 1. Then 2, it says all authority of the state emanates from the people. All authority of the state emanates from the people.
From us, the people.
From us, fe. Yeah? And the people shall be governed through their will and consent. That's sub 2. Then sub 3, it says again, all power and authority of government and of its organs derive from this Constitution, which in turn derives its authority from, guess who? The people. the people.
Fe bana Uganda.
And we consent to be governed in accordance with this constitution. Okay. Then the sub-article 4 is that we will express our will and consent on who will govern us through periodic elections, which we've been doing since 96. Okay. So in a nutshell, sovereignty, power belongs to the people, and we are governed by our will and consent. Now, this theme recurs in other provisions. When you look at the judiciary, they exercise power from the people, okay? And it's exercised in the name of the people. Imagine even the UPDF, okay, is made subordinate to civilian authority.
Even the UPDF.
Even the UPDF.
That's a new...
Yes. Then if you go to what is called the National Objectives and Directive Principles of State Policy, it says all public offices are held in trust for the people.
So they just hold it for us.
For us.
Not.
So who is the owner?
Us Ugandans.
Bwananyini, bwani?
Us Ugandans, yes.
Yes. Obuyinza bwani? Bwaffe. Eggwanga lyani? Lyaffe. You see, that is sovereignty. So all those public offices are held in trust for us. All positions of leadership and responsibility in their work must be answerable to who? The people.
The people.
Okay. So members of parliament are, in Uganda, how do they refer to them? Yes. Abakungu.
Abakungu.
Yes. Our representatives. So who has the power? It is us.
Us, the people.
The people. They are just our representatives. Like we've seen, public offices held in trust. So Bwananyini is ours. We are the sovereign. We are the sovereign. These people in government are there because of our power.
Us, because we chose them
Thank you very much.
Just represent us.
Yes, and they're exercising whose power?
Our power.
Our power. Not theirs. So that really, really, really tells us what went wrong with the bill in origin. Because the original bill, what it did was to take that sovereignty and say they are protecting it and give it to a single appointed official, the Minister of Internal Affairs, and said now for you to exercise your rights, you have to go and ask for permission from Internal Affairs. So they inverted it. The sovereign now became the minister. Who is appointed by who? So that was what drove the main objections from a legal perspective. And those elements are still there. Yes.
All right. So now that we understand what the sovereignty is, so the bill was tabled before Parliament.
Yes.
And there were so many quotations that came up, everyone having their own say on this affects me, this is unrealistic, and amendments were made in regard to the bill that was passed. So what is the difference between the bill that was tabled before Parliament and the bill that has been assented to by the President?
Okay. Thank you very much, Justin. So the government had this apprehension of money being brought into the country to interfere with our political processes. Okay? So it cast a very, very wide net to catch anybody who was receiving money from abroad. Okay? It defined foreigners as, for instance, companies, legitimate business companies with foreign shareholding. Diaspora Ugandans were also defined as foreigners. Okay? And then after casting that definition of foreigners, it then tried to put restrictions on who receives money from foreigners and what they can do with it here. So everybody was suddenly caught in a very, very, very wide net. Did you know, for instance, that Uganda receives $1.5 to $2.5 billion per annum from diaspora Ugandans?
Only.
I'm not talking about foreign direct investment. I'm talking about our brothers and sisters, our sons and daughters who are out there. There's a word for them. There's a word for them on the street. Those people who go out to do that kind of work. They send us this $2.5 billion. I call it democratic and committed money. It's committed because the money comes to provide for school fees. Okay, someone goes and sends school fees for siblings or children, sends money for healthcare for their parents, okay, sends money for small businesses for their siblings and so on. So it's committed because that kind of money will come. It doesn't matter who is in power. It doesn't matter whether the government does what hostile act.
The money will come.
Yes. You remember when we passed anti-homosexuality legislation?
Yes.
And some people said we're not investing in Uganda anymore.
Yes.
But here, because someone in Saudi Arabia is sending money to their mother to go to hospital, they
still
really
have
don't
to.
care what the government is doing. They will send that money. So I call it committed. I also call it democratic because border to border, from Kisoro to Kidepo, okay, from West Nile to Busia, Gulu to Buganda, somebody has somebody abroad, okay? It's not for a particular region that maybe those who grew up near the lake are eating the fish.
Eating the fish.
In Busia, they eat fish because they are next to the lake or in this area, they eat that kind of thing because it grows well there. No, this is countrywide. Those monies go countrywide. So I call it very, very democratic. So the government tried to interfere with those flows. But due to the massive, massive outcry that was received from the public, and by massive, what am I talking about? From charity organizations like Rotary International,
yes,
to faith organizations, from the Muslim community, the Christian community, to professional associations, the architects. Have you ever had the architects make a public statement?
It was my first time.
Yes, about Rotary International, making a public in Parliament, okay? Then the professional associations, the lawyers, okay? The regulators, like Insurance Regulatory Authority, like we also had Bank of Uganda appearing before Parliament.
And in
yes, and represented by their governor and deputy governor and director for payment systems. Okay, that was massive. So there was a massive outcry or pushback to the bill. I think they received 53 testimonies, 52 or 51 were in favor. The ones against included Honorable Yusuf Nsibambi. He was in favor, but everybody was saying no. You have to change this.
Change the bill.
You have to change this. And interestingly, the trend was exclude me, get me out of this law, get me out of this law. And that's exactly what the government did. So the law was amended to provide massive exclusions. So if you're a legitimate licensed business, let's say a bank or an insurance company with the foreign shareholding, you're excluded from the definition of a foreigner.
So who is still in the definition of a foreigner?
That's a very good question, because you have to understand who the legal subject of the law is.
Yes.
Against whom is the law going to move? And really the law now is going to move against somebody here who is receiving money from outside countries, as we call it, and using that money for political activities. Okay? So to be an agent of a foreigner, you must be receiving money from abroad and using it for political activities, as we understand political activities. There are some ordinary civic duties or civic rights which are included in the definition of political activities, but we'll get to that. So in a nutshell, you are receiving money from abroad and putting it in
political
politics.
activities. Were there other amendments that were made just apart from...
Yes. There were some horrendous offenses, okay, which are called strict liability offenses. In other words, there is no defense. You do a certain act. Yes. You do a certain act, you go to prison for it. It doesn't say you did it on purpose, that you did it with a mental element. So many of those were amended. Now the law requires you to have done willfully or knowingly. Okay, then they reduced many of the penalties from the billions. Largely, they were reducing them by half, except a certain provision against banks and payment agencies, which still remains full. But many of the offenses, the penalty was reduced, the jail term was reduced.
All right. Yes. So with these amendments, does it reduce the concerns that civil society and all the groups of people that came before Parliament to request the bill to be changed? Are the concerns reduced? Yes, definitely. If you called people to come back, if they had gone back to public and said, we have another week of public hearings, I think from the 53, probably it would go down maybe to like 10. Because it's now largely
lawyer issues, largely lawyer issues, the legal concepts. Yes, they concern everybody, but it would be a lawyer articulation. For other businesses, they can go about them as they do. The other area would be the banks and the money remittance agencies. They have a big problem around reporting of foreign funding. And I'm going to explain that a little bit more. You see, the government is worried about money coming into the country to be used or misused for political activities, depending on how you look at it. Money coming into the country, where does it pass? It goes through banks and mobile money agencies, Western Union. That's where it passes. So if you wanted to control who receives that money, where would you stand? You would ask the bank. You would ask the bank to be the gatekeeper.
The gatekeeper.
Yes, it makes logically that.
Yes,
that's
you need
the right
to have
thing.
control
Logic.
of the gatekeeper.
Yes, logic. If you want to stop someone from scoring a goal, you don't stand at halfway line. You stand in the goal mouth. That's where the goalkeeper is stationed.
Yes.
So the money is coming through the bank. If you want to see who's getting it, where are you going to stand? In the bank. So they have put a duty on the bank not to pay money to someone who's going to use it for politics.
I think we shall get into that later, but
Yes.
as of now, how will the bank be able to differentiate
Yes.
I who is just getting money and another person to know this money is going for, all the money is from the foreign agent, but
Yes.
which money is for political activities?
Yes. It's a real problem. It is a real problem for the banks and money remittance agencies because they really have no way. If you're obviously a politician, I keep using the example of if Joel Senyonyi shows up and says, "Oh, I've received $5,000 from Donald Trump." If you pay him,
political activities.
If you pay him, I mean, that's on you. You should have known. You see, that's on you. Okay, but he could really be receiving $1,000 from his brother.
Yes.
And is going to use it to build his brother a house. Okay?
Yes.
Now, how is the bank to make that determination? How is the bank to decide you're an agent of a foreigner, you're not, you're using it for politics, you're not? That's where the unfairness of that Section 25 obligation is.
So, since we are already on the Section 25,
Yes.
practically, do you think this bill, this act's now an act,
Yes.
do you think this act is going to get issues in terms of it being put in practice?
Yes, it will. It will, because like in the case of the banks and money remittance agencies, you're putting them in an impossible situation to comply with. Okay? And the offense, if the bank gets it wrong and gives money to our Joel Senyonyi, the example we're using,
Yes.
and uses it for politics, okay, the penalty on the bank is up to $1 million.
$1 million.
$1 million. It's up to, it's 4 billion shillings, which is
1
about
million,
$1 million. Okay? Yeah, and it's strict liability. The bank cannot say, but I asked him, but I know him, and he actually told me and showed me his brother's site. No, it's strict liability. Strict liability, you give the money to him, he's an agent of a foreigner, you're liable. Okay? So it's an impossible situation. And what is really compounds it is that regulated entities like banks or money remittance agencies, compliance standard is zero default. Zero default. They follow a straight line. There is no gray area. Okay? So now they are struggling to see what can they do to their systems to see if they can implement the law. Now, you must also think that banks, and I'm going to use banks to cover remittance agencies as well, a customer may receive money into his bank account and he can take out his phone and send it, spend it.
Yes.
At what point does the bank intervene?
Because now we have online.
Thank you. It is straight through to the customer. From Donald Trump, he can put it on my phone.
And I
can
pay
get
right
it off
now
my
when we are
phone
still on the podcast.
and pay
yes.
borders to go and
Yes.
riot. And, you know, so at what point does the Momo agency or the bank intervene? Yes, there's also a customer who receives money through Western Union and is required to go to a bank branch, present ID before he receives the money.
Yes.
That one they may ask him, you know, declare your source of
Your
funds.
source of funding.
And they may also ask what are you going to use it for and why and so on. But it's not a simple test, because if he tells a lie, it's not a defense for the bank.
It's a strict liability.
Yes, it's a strict liability offense.
So, to that, doesn't the act need regulations, and how immediate will the act take effect?
Yes, thank you. This act does not have a commencement clause. Section 1, it should have said the act commences on such and such a date. Now, where an act does not have a commencement section, it takes effect immediately it appears in the Uganda Gazette. Okay, so if it is published in the Uganda Gazette, today the act is now in force. All its obligations are applicable.
If the bank receives money and it is used for political activity from
Thank
a
you.
foreign agent,
Immediate default.
immediately.
Immediate default. Their risk, just has shot through the roof. Regulations, the act requires regulations to be implemented. For instance, if I want to register as an agent of a foreigner, who do I see? What information? What does the document look like? How much do I pay? Okay.
What form?
It's not there. If the bank is to query me, how should they do it? Okay. Are they empowered to hold my money? Okay. Before they give it to me? Those kind of questions. Regulations should address it. Unfortunately, we don't have a good track record on making of regulations. The Competition Act came out. They put a special provision and said regulations shall be made within 6 months. I think it took them 14 months to make the regulations.
With this act, have they put out a specific period when its regulation should be out?
No, there's no time period. I think they learned from the Competition Act that time period in Uganda doesn't
comes
work.
Back to
I
bite
came
you.
late for this interview.
So,
Yes.
so looking back at the legislative process, do you think Parliament was provided with sufficient information on the economic and governance effects or the implications of the bill? And were there warning signs or indications that, in your view, deserved greater attention before the bill was passed?
Yeah. Government did not consult adequately, and Parliament was not given sufficient information, particularly on the economic implications of this law. The main instrument that informs Parliament on economic implications of a law is a certificate of financial implications. Every bill going to Parliament requires a certificate of financial implications, and this is issued by the Ministry of Finance. Now, in this case, the certificate issued by Minister Amos Lugolobi, okay, was not a certificate of financial implications
What
at all.
was it?
I think you would say certificate, because it's supposed to give revenue and expenditure estimates for 2 years.
Yes.
What revenue are we going to get on this bill, and how much are we going to spend implementing it? It gave a figure out of the blue, completely unsupported. Okay? And on revenue, it said this is not a law that will generate revenue. But how do you say that when in the bill you required thousands of people to register with you? Okay? And
Yes.
therefore you'd be entitled to charge a registration fee. When you provided for renewal of certificates of registration, thereby earning more revenue. And then when you had $1 million penalties, how can you then say that there's no revenue
There's no
coming?
revenue when the penalties are in
Do you know how
millions.
much is we collect in traffic fines? I don't mean the ones that the traffic police put in their pockets, but
That's the whole...
you get the point.
Yes.
So that the bill, definitely it was wrong to say that it's not going to generate revenue. Okay. Then on economic implications, the paragraph in the certificate, which was supposed to deal with economic implications, what the minister did was to repeat the objectives of the law. He did not say this is about cross-border payments. He did not say this is a dangerous law for us because it is interfering with foreign remittances, which are, supporting our balance of payments position,
Yes.
which have helped us build $6.5 billion in reserves. And that if we interfere with it, we could depreciate our currency, erode our reserves. Okay, these are the words of the Governor Bank of Uganda. And he concluded by saying that a country without reserves is not sovereign. Now, when he said that, you could hear a pin drop. Now, this is the economic implication. Where was Bank of Uganda when the certificate was being written.
One would say it was not consulted.
Thank you and that is pure and simple. It was not consulted. And you can see the whole game changed once Bank of Uganda said, look, you are risking our economic stability.
Right, thank you. So we're going to take a short break and we shall be right back.
The Center for Policy Analysis is an independent think tank shaping parliamentary democracy, governance, and public policy in Uganda and beyond. Our mission is to shape public policy and strengthen democratic governance by delivering high-quality research, fostering collaboration, and empowering citizens. Our vision is a democratic society with transparent, accountable, and responsive governance systems. What sets SEPA apart? A unique consortium model that integrates expertise from diverse partners for multidisciplinary approaches. We pioneer thought leadership, leveraging tools like artificial intelligence to enhance impact. Through collaborative advocacy, we empower stakeholders to engage with legislative processes, all while combining rigorous research with a deep understanding of Uganda's political economy. Our flagship initiatives include Parliament Watch Uganda, that bridges the gap between the citizens and Parliament, the Policy Digest podcast that explores politics and public affairs across Africa, and the SEPA Convo, our bi-monthly X-Space tackling key public issues. Our work spans parliamentary democracy, human rights, public health, road safety, climate justice, artificial intelligence, and more, including the Africa Regional Conference on Parliament and Legislation. Join SEPA in shaping policies, amplifying voices, and building a democratic future. Visit www.sepa.or.ug to learn more or follow us on social media. The Center for Policy Analysis, a leading public policy think tank.
Hello and welcome back to the Policy Digest, and we're continuing with our conversation. So, Philip, what are your comments on the response that civil society and Ugandans at large had in response to when the bill was tabled?
Yes, thank you, Justin. I think Ugandans have got a lot to be proud of. The response was massive. We demonstrated a lot of civic awareness and competence, maybe because the bill affected us in our different spheres of life personally. But whatever the cause, it's a good thing that people stood up and made their voices heard. And the response was well received by government, well responded to, meticulously responded to. The Attorney General seems to have gone complaint by complaint in effecting his amendments. So the act has got little resemblance to the original bill.
Yes. So the civil society fought the bill.
Yes.
But the bill is here. So how can civil society work within this new regulation or this new act and not be caught or cast in the net?
Yes. First of all, let's premise that the civil society opposed the bill, but it was still passed. Is it a loss? No, it is not a loss. It's I wanted to think of it in terms of somebody comes to your household and makes away with your goodies. No kubire ndulu, no musuza. He drops some things as he runs away. And it's still a victory for you. He may have gotten away with something, but it's still a victory. But in this case, we must recognize that there is a legitimate concern to protect our sovereignty. It's just the way the government is going about it that we have concerns with. But there is a legitimate concern of saying who can influence our politics. So how does the civil society then operate within the new legal framework?
Yes.
It depends on what it is you do. If you are receiving money to engage in political activities, you must register as an agent of a foreigner. Okay? If you're receiving money to engage in political activities, as defined in the Act, okay, or as we understand political activities in common parlance, then you must register as an agent of a foreigner. Okay? If you're outside political activities, then go and do your business as usual. Yes.
Yes. So is there still a section of economic sabotage in the amended bill or the amended
Yes.
act. Okay. So with that question, do you think civil society organizations, journalists, researchers, because sometimes research needs you to scrutinize some things, even the policies that are made, self-censorship, even before the act is hand-headedly put in practice?
Yes, let me deal with it one at a time.
Yes.
The prohibition of economic sabotage is still there in Section 13, okay? And it prohibits any act, speech, publication that may damage the economy, okay? In itself, the section is problematic. The offense is problematic. Primarily, as a speech offense, the Constitutional Court has told us 3 times that you cannot make speech a crime. Okay? You cannot make speech a crime unless it's inciting a genocide or something in that category. But simply stating that the dollar is going to go up or go down will never be a crime.
You're not committing a crime.
Yes, on the standard set by the Constitutional Court. Will it create self-censorship? Yes. Sekauka galika kulumieko. Because the government has shown an intention, a malevolent intention to come after you. Now, the minute you see, you begin, to be careful on your own. It's like being in a bad relationship. Someone has shown you anger, he has shown you capacity for violence. You also start walking on eggshells. So that it will be an unfortunate part, but we will be standing on constitutional rights. Okay, the Constitution provides a right to engage in our governance. Okay, so hopefully that's where we shall get courage from to continue the work that is necessary.
Yes, so there will be self-censorship just so that they can avoid being caught on the wrong side of the law.
They may be, but hopefully people will take courage from the Constitution.
Yes, so with that, are there going to be like sort of a challenge to the law? Do you think Ugandans will come up to fight this act?
Yes, there is going to be a challenge. I can safely say that the Uganda Law Society is definitely engaged and will file a constitutional petition as soon as the act is published. Definitely. I have heard of other groups also preparing, but I'm not engaged with the other groups. Yes.
So since you've mentioned that, what sections in the act that was assented to do you think are most likely to face sanction by the court?
Okay. There are 2, let's call it 2 arms to a constitutional challenge to this act.
Yes.
First is procedural. The procedure taken by the House in passing this law violated the Constitution. Let's start with quorum. The Speaker did not take the necessary steps to confirm before the vote on the bill that there was quorum in the House. And secondly, she did not make a record of the voting on the bill. So first, she's supposed to do a head count at the time the bill is being voted on.
A head count.
A head count, and say there are at least 30% of the members entitled to vote in the House. Then secondly, when the vote is done, she's supposed to make a record of how many people voted for, against. And abstained. And you see, the Constitutional Court determined that this year, in a case called Alternative Digitalk, when they nullified Nseriko's bill, you cannot pass a law by saying the A's have it.
And the nays have it.
No, when the A's have it, then the nays don't have it. Yes.
Have it.
Yeah, you can't do that anymore. You have to be specific and you have to have that record. So she didn't. She referred to the earlier counts in the House that Joel Senyonyi had driven and said, I still have my quorum. But those counts were, 20, 30 minutes before. And you're required nonetheless to make a record of actual voting on the bill. So she didn't. So that's quorum, number 1. Number 2 is the certificate of financial implications, which I have said was not a certificate at all. And if it's not a certificate, then the bill as presented to Parliament was not accompanied by a valid certificate of financial implications. Okay. Number 3, there's an argument that given that the bill was so massively amended, 18 out of 30 clauses were amended.
18.
And it's not just quantitative, but whole qualitative Okay, the definitions that drive the act were amended and reoriented. Okay, so it was no longer the same bill that the public commented on.
It's
Okay.
almost a new bill.
It was, thank you very much. It was almost a new bill. So you needed to go back to the people and get their comment on that.
And then
Yes, on the new bill. So there's also an argument around the denial of effective public participation, because from first reading to passing the bill was like 21 days. Yes, it's true many people went to parliament, but what was the rush? Where was anybody going? Okay, why don't you let the people air out, let them consider? Also, government winning them over. Because before we could understand it, before we could understand what government is trying to achieve, maybe we'd support it, maybe we'd see how else to achieve it. It's been passed. Okay? Now, so those are procedural issues.
Okay.
Substantive objections. You remember I've said sovereignty. Bwananyini. Okay?
Buffy.
So that contest of whether you can decide for Nanyini how to exercise his sovereignty is a fundamental constitutional objection. Okay? You have a gatekeeper at the gate keeping security, but you're Nanyini here. But the gatekeeper is the one to decide for you.
When you enter and when you leave.
When you enter and when you leave.
leave.
Okay, and what you do when you're inside. I used to have a
that
dog.
is you being a prisoner.
Yes,
of your
I used to have a
gatekeeper.
dog like that. You know, I needed to check where the dog was before I got out of the house. So who was the Nanyini then? And who was sovereign in the home?
In the home.
It was the dog
The
ruling
dog
me.
had.
So the executive has got no say in controlling how we exercise our sovereignty. It's given by us to us in the Constitution. It's guaranteed in the Constitution. Okay, the only limitation they can do is what is demonstrably justifiable in a free and democratic society. Now, the other objections is they are curtailing freedom of association. Okay, first of all, generally, because if I want to bring a policy to improve childhood nutrition, and there's a childhood nutrition society in Egypt that wants to help me achieve it, why can't I get that money and use it here? Okay, why can't I get that money and use it here, and then tell government we need a new law on childhood nutrition? Every child must have 25 grams of protein per day. Let's make it a regulation. Let's send it to the local government. Let's send it to the schools. I will be influencing a law, a policy, but I'm not supposed to do it with foreign funding. I would be an agent for over foreigner immediately. Okay. Now, what is the problem with that? Do you see any problem with that? Is it averse to national interest? There's also a contest that the way they have defined the interests of Uganda is actually the interests of the ruling party.
Yet more light on that.
Yes, because when they're talking about sovereignty and acting for foreigners, they talk about the interests of Uganda and the interests of foreigners. And they link it to government policy. But the government policy today is made by the ruling party. And we know there's opposition who have other ideas about what should be government policy. So you can't criminalize opposing ideas. Then that's not a democracy. That's not a democracy anymore. Okay? In a democracy, they must be contending, contention of 1,000 ideas. Okay, so those are fundamental legal objections to the act as passed. We've talked about Section 13 on economic sabotage and how it affects the freedom of speech, as recently passed by the Constitutional Court. Not just alternative digital case, but even Charles Onyango-Bo, which is more than 20 years old, which nullified the offense of false news in the Penal Code. Then there was a case of Mwenda, which nullified the offense of sedition. Speech is free in democracy. And it is necessary, I think Justice Mulenga said, it's necessary to hear opposing views and to protect, in particular, views that one may find offensive or different from your own.
Wouldn't one say that the right to expression literally covers the other rights because it helps you protect them?
Yes, there's a word for it. Without the freedom of expression, you then cannot really enjoy the other rights. Yes, how would you enjoy religion? How would you enjoy your right to religion? How would you enjoy your right to associate? if I cannot reach out to people and create like-minded thinking, a platform for action.
I get you.
Yes.
So, civil society, one would say that they had what they went through with the 11th Parliament, especially towards the end, and even how one would say their voice not being heard or something of that sort. So what lessons do you think civil society should take up as we have a new parliament, the 12th Parliament, so that some things don't repeat themselves?
Yes, thank you. I think the civil society experience on this Protection of Sovereignty Act is a victory. Okay, it's a victory. And what we learn from it is that eternal vigilance is the price we pay for liberty. That quotation is attributed to Thomas Jefferson, but there's controversy as to who said it. But the lesson for us is teri kuzikiza. Keep your eyes open, keep engaged. It is your right as a citizen, okay, to participate in your governance. It's your right to speak up, okay, and defend the Constitution. So we must be aware, and organizations like yours are helping to bring to the public eye, to the public attention, what's going on in public. And then if Feba Nanyini, when people are making decisions, we must engage. We must be involved. It's our constitutional right, okay? And we've seen in the Protection of Sovereignty Act, Okwe Kubira Endulu, it helps.
It helped us.
Yes, it helped us. Because if that original bill had been passed, it's hard even to say where we would be. It would have, Bank of Uganda said it, okay? It was going to be an economic disaster.
For Uganda.
For Uganda, yes. And we are speaking economic terms. We're not talking about civic rights. We are speaking pure economics, hard dollars and cents. Or should I say shillings, since we are talking about sovereignty?
Shillings. I think shillings
would work. Yes.
Yes. So thank you very much. I have personally learnt a lot. And we hope as Ugandans, the court will hear us. That's what I can say, the Constitutional Court. It has heard us for most of the times. And it has been a pleasure. Do you have any last words you would want to address? I don't know.
I'm good. Thank you very much, Justin. It's been a pleasure being here. And I thank you everyone who's watching. And I hope that we can take these lessons forward to participate in the governance of our country. Thank you very much.
Thank you very much. Thank you very much for watching. This was the Policy Digest. Follow us on all our social media platforms at SEPA Uganda, Home of Parliament Watch, on YouTube, TikTok, and X.
Thank you for listening to the Policy Digest podcast, the Center for Policy Analysis podcast that is profiling African ideas and people that are shaping the future of their communities. Subscribe to all our platforms on YouTube and Podbean.